welcome everyone to our 19th Esports Lunch Lecture Germany. My name is Nepomuk Nothelfer, and today I have the pleasure of hosting this very special session of the ELLG. First of all, to all the newcomers, what are the Esports Lunch Lectures Germany? Well, every month we strive to bring you our guests closer to the specific of esports law in Germany, while sometimes having more of an international look on esports and related topics, as for example today. And as always, there will be 15 to 20-minute presentation, which will be recorded and uploaded to our YouTube channel SKW Esports in about a week or two, maybe 3 weeks. You will get a notice. And you'll be able to see the link to our SKW channel and our newsletter, by the way, in the chat in a few moments. And after the presentation, we'll have a Q&A session, 10 to 15 minutes, which will, of course, not be recorded. That means we're completely among ourselves. You can ask any question you like in the chat. That's important. Ask your questions in the chat. But of course, if you will get an answer, is up to our speaker. And talking about our speaker today, we have the best speaker you could ask for regarding probably the most interesting esports law topic at the moment. You can already see it on your screen, the dispute resolution for Riot Games Esports EMEA, or short, the DR. I would like to welcome our speaker, Valérie. Valérie is the EMEA Esports Rules and Compliance Manager at Riot Games, where she has been leading the EMEA Esports integrity efforts for over 2 years in Berlin now. Crazy that it's already over 2 years. Valérie has extensive knowledge about all things ethics, integrity, governance, sports, and of course, therefore, dispute resolution. She worked in relevant roles, among others, at FIFA and the International Hockey Federation. So without any further ado, Valérie, we are so grateful and happy to have you here today. Thank you so much, and the stage is yours.
Thanks, Nepo, and welcome everyone. What an introduction that actually makes me skip the first slide, which was going to be about introducing myself, but I think Nepo, you already did such a great job talking about my background and my current role, so I can spare some of those minutes. First of all, thanks for inviting me from SKW Schwarz to speak about this very new project that we just launched 1.5 weeks ago now, and I'm happy to speak about it in a bit more details, also focused on the lawyer's perspective, because I think it's quite a new project in esports as a whole. So for those of you who are not familiar with Riot Games, I know some of you are very much familiar with it, but maybe some of you here are coming more from the legal side or from the sports law side like myself. So just a quick intro about Riot Games. It's a video game publisher. I work in Berlin at the EMEA headquarters, where we're focusing on esports, but overall there's over 4,000 employees and over 20 offices worldwide. So it's a pretty big company, I would say, and probably one of the biggest video game publishers and also biggest key players in esports. Just a brief history of the company. So it was founded in 2006 in Santa Monica, LA, a bit nicer weather than currently here in Berlin. And just after 3 years, they launched their first video game. So it was actually just one game at the beginning in 2009 of League of Legends. I'm sure some of you play this. And what is amazing is that it's still one of the most popular games, even now, so many years thereafter. They became competitive with their first World Championship in 2011. And 10 years after the first launch of the game, they decided to expand their portfolio in more than just one game, which I'll just come to in a minute. So currently, we have 5 games, and 2 of them are kind of leading in esports, I would say. And now this year, we're focusing on renewing our games focus. So there's some exciting updates coming soon from Riot Games. As I mentioned, we have mainly 5 video game titles, League of Legends and VALORANT being the top ones, together with Teamfight Tactics, League of Legends Wild Rift, as well as Legends of Runeterra. And you see a question mark there because there's some exciting news coming soon in that sense of extending the video game titles. Also, if you've never heard of esports, it's a thing, it's real. Here are just some impressions from some of the biggest events that we've hosted over the years. Me not coming from this background, but coming from sports, I was really amazed when I participated the first time in such a live event. We just hosted also our League of Legends World Championships a few weeks ago at the O2 Arena in London. And it's always packed, as you can see in those images from Paris, Shanghai, San Francisco, and Seoul. Usually tickets are sold out within a few minutes, which just shows you the massive fan base of here League of Legends. But without further ado, I'll come more to the relevant topic today. So as Nepo mentioned in my introduction, I'm within Esports Rules and Compliance in EMEA Berlin. And this craft is relatively new. In general, for Riot Games, it has been established 3 years ago with my counterpart in LA. And now we're actually represented all over in Singapore as well as in Americas within competitive operations. What do we do at Esports Rules and Compliance? If some of you are familiar with international sports federations, such as like my background, it's we kind of do everything that you would do in, for example, regulatory, in disciplinary, in ethics, as well as in awareness and education. So this means that, for example, we have the Esports Global Code of Conduct, which is a code of conduct for all of our professional and semi-professional players, teams, and coaches, with several rules that they have to adhere to for a safe esports environment. And then, of course, if there's a breach to such a code of conduct, we would then likely investigate it under confidential terms and issue a decision that can span from a warning to a fine to even a ban from the ecosystem. And last but not least, something that's, of course, also very important is that we're focusing on awareness and education, as well as governance topics. So today I'm going to actually speak on one of the governance topics, the dispute resolution for Riot Games EMEA Esports. And also exciting, you can see a link here to our new website where you can actually read all about our craft. And this is the Global Competitive Operations website, where you can find also all the regulatory rule books and decisions, as well as some articles on, for example, our efforts within match fixing. So today I'm happy to speak about this very new project, and I'll walk you through some of the key points. First of all, it's always important to take a look and zoom out a bit, like why did we start doing this project? And it has several reasons. One of them is that since I've been working within esports in Berlin, a lot of cases have come to us where either players, coaches, or teams have had issues with their contracts. And they come to us and they usually ask for help to intervene in such disputes. But these disputes or employment contracts are just signed between those two parties, so we would not be able to intervene from Riot Games' position. And we would ask them to either try to amicably settle that kind of issue or to go to an ordinary court. What has happened was that either the players or the coaches didn't have the means, or the teams wouldn't want to sue a player, and therefore a lot of these kind of issues were unresolved within our ecosystem within EMEA, which then led to contractual instability. Contractual instability in an ecosystem, in any sort of sports or esports ecosystem, leads to a lot of other problems. First of all, the stakeholders, so players, coaches, and teams, don't feel very safe, let's say, or cannot only focus on their gameplay if they have other issues ongoing and not knowing where to take them. The other thing is, especially in lower leagues, if you have a contractual instability, you're also prone to some integrity issues. So, for example, a player might then be more motivated to fix a match in case his contract is not adhered, because he's outstanding salaries not being paid, but he still needs to pay rent. And if a fixer then would approach him, he would more likely than not take this money just to survive as an esports player. And of course, we don't want that in Riot Games. And this was one of the main solutions we saw, that we need to provide an independent court of arbitration where these parties can take those issues and solve them very fast and efficiently, and also have this accessibility. The other reason was that also from my background, I actually started 14 years ago as a sports lawyer in Zurich at FIFA, and within dispute resolution, and I've seen the effects, the positive effects that the dispute resolution chamber at FIFA had on the ecosystem by providing this kind of trust and contractual stability within football. So we want to replicate that within our esports ecosystem, and that's why we were able to initiate this project within our region EMEA at first, and see how it goes to maybe expand it globally at a later stage. So the core principles when we were looking at this dispute resolution system was that it should be fair, it should be efficient, and it should be accessible. This is really important because esports is still a little bit less developed than maybe some other sport leagues. So it's very important that, especially the third point, that it's accessible. I will come to who can use this dispute resolution, but we have a lot of parties, players, coaches, and teams that are not making so much money in our second tier, and therefore it really needs to be an accessible dispute resolution. Now I want to take you through the next steps, imagining that we have this player, let's call him Alex. It's a young esports player, and he's been grinding a lot to finally make it as a semi-professional player in one of our League of Legends regional leagues in France. He's joining a promising team in the LFL, and he's doing really well. He just signed a one-year employment contract with his team. Although the salary is low, he's super happy because he might make it into the Tier 1 or League 1 at a later stage for League of Legends. However, 8 months into his contract with his team, the team stops paying him his salary, and this is now 2 months already. And he's really struggling with paying his rent, his other costs that he has, and he doesn't know what to do. So his salary is very modest. He only receives 2,000 euro a month. So this would be 4,000 euro, which still is a lot of money for him. So what does he do? He can then take this claim now to the dispute resolution for Riot Games Esports EMEA. Because this body resolves contractual and financial disputes. So this is a typical dispute that the body would hear. And it's applicable for our players, coaches, and teams in our Tier 1 and Tier 2 League of Legends and VALORANT ecosystem. So here Alex is playing in the LFL. This would be League of Legends Tier 2. What is also super important is that this body is voluntary. So it's only up to the parties if they want to use it. And it's also completely independent. In this case, Alex is super lucky because when he negotiated his contract with his team, he put in the arbitration clause referring to the dispute resolution, saying that if there is a dispute, the parties can use this mechanism. If he would not have this clause in the contract, he would still have the possibility to use the dispute resolution body if the team would agree to do so by signing an arbitration agreement. But as you can imagine, if somebody owes you money, that is difficult to then maybe get across the line. What is also super important is that this body is independent. We used a German law firm called Martin's Lawyers that set this up. So Riot Games initiated it, but it was completely set up independently by Martin's law firm. And why did we use this law firm? Because they are the ones that have founded the Basketball Arbitral Tribunal for FIBA, which is one of the most popular arbitration courts in sports. So we want to replicate this success in esports. Now, coming into the details from a legal perspective, as I mentioned, very important, it's voluntary. Here is a copy paste of the standard arbitration clause, which is of course also in our arbitration rules publicly available, where both parties agree that they can use this dispute resolution. So Riot Games cannot impose the jurisdictions on the party, and it's really up to the parties to do so. So we will also see the success of this body by the amount of future employment contracts or transfer agreements that will have this arbitration clause in there. Another very important key feature was when Martin's lawyers thought about, okay, where is the seat of this arbitration going to be? They came up with Switzerland for many reasons, because it is one of the countries where a lot of arbitration courts are already implemented, such as the Court of Arbitration for Sports, which is kind of the Supreme Court for sports. But also, for example, the one that they set up for basketball is seated in Switzerland. So therefore, Swiss arbitration law would apply. And because also in Switzerland, of course, the employment-related disputes are arbitrable, which is also something from a legal perspective that is not applicable in all the countries. And more likely than not, the jurisprudence is also arbitration friendly. When we look at the procedure of the dispute resolution, the common goal is to have efficiency and to reduce the costs of the proceedings. So this was really something when Martin's lawyers was designing this dispute resolution body, thinking of to have an efficiency and an accessibility. So here, Alex takes his case to the dispute resolution via our website. He can submit a complaint form. He does not need a lawyer. I'm sorry for all the lawyers here, because it's very easy. Of course, he can get a lawyer, he can get an agent or his uncle to represent him if he would like to, but he can just fill out this form. What happens next is that the Martin's lawyers, as the secretariat, will receive this complaint and will check if they need additional information and then appoint one of the sole arbitrators. They've appointed 14 arbitrators from all over the world that are specialized either in arbitration in commercial disputes or in sports law. And one of those arbitrators will be appointed to Alex's case against his team. Then what happens next is that, which I will get to later, he will have to pay a handling fee. And his complaint with all his facts and copy of the contract will be submitted to the sole arbitrator, where they will then ask for the position of the team being the debtor here, in this case, owing the player 4,000 euros. There will be only one round of written submissions and no hearing as a default rule. Of course, if the parties want to have a hearing, that is possible. But again, this goes into the efficiency model. And last but not least, once the decision will be made by the sole arbitrator, there will be an award issued, a short summary of the award without going into the details. Again, having the efficiency goal in mind. The decision, this is also something very interesting and something quite unique, I would say, that has been used by the Basketball Arbitral Tribunal that has been established since 2007, is that the arbitrator decides the dispute ex equo e bono. Some of you might be familiar with this term, but it's basically that you're not looking at an application of the rule of the law, but rather to what is fair and just. So looking at the dispute itself, at the contract, and maybe then default interest should apply, even if that has not been contractually agreed, because that would be what is fair and just according to standard procedures. Also, pacta sunt servanda and other principles of equity and fairness would apply in such a procedure. And again, the advantage here is that that really simplifies and speeds up the proceedings, because the arbitrator will not have to study the different laws, let's say, or have this type of knowledge, but instead base it on fairness and justice, and also on the expertise that they might have through other arbitration proceedings that they've led. Now coming to the costs, this was also an important factor to accessibility. So as I mentioned, when Alex submits his complaint against his team, he has to first pay a handling fee. That covers the administrative fee of the secretariat of the dispute resolution. And it ranges between 500 euros and 4,000 euro, depending on the value in dispute. Again, here you can find all the details in the arbitration rules as to how much it would actually cost in a given dispute, depending on the amount. And this is to be paid by the claimant, so in this case by Alex. Again, here I mentioned that he has an outstanding amount of 4,000 euro, 2 months of his salaries, so it would be the lowest fee of 500 euros that he would have to pay. Once it's then submitted, there is the arbitrator fee that has to be paid. This is a fee that has to be paid by Alex and the team 50-50. And this is to cover the costs of the arbitrator. These costs are also relatively low compared to other commercial dispute resolution or arbitration courts, and they range between 1,000 and 5,000 euros, again, depending on the value in dispute. Here, it's a relatively low amount that Alex is claiming, 4,000 euros, so we would apply the lowest fee of 1,000 euro, meaning that Alex has to pay 500 and the other party, being the team, has to pay 500 euro. So this means Alex needs to pay in total 1,000 euro to get his case heard. Now that might sound quite high if his monthly salary is 2,000 euro. Therefore, we've established a legal aid fund for our lower tiers, tier 2 in League of Legends and VALORANT, where we have a fund that would then cover the entire handling and arbitrator fee of the party submitting the complaint. There is an eligibility criteria, of course, that we've looked at, and so here Alex is can apply for it because the amount in dispute has to be maximum 8,000 euro, and his annual salary would have to be 30,000 euro gross in total. So here, with 4,000 euros in dispute and his annual salary being 24,000 gross, he can apply for the legal aid fund, and his arbitration will be entirely free for Alex. Once the decision is then made based on ex equo bono, the arbitrator, the sole arbitrator, will provide the decision, the award, to the parties, and it will also be made public on our website, unless one of the parties wants it to keep it confidential for whichever reason. It's up to the arbitrator to decide whether it can be held confidential or not. Now, Alex is happy because the arbitrator awarded him 4,000 euro, the 2 months outstanding salary, plus default interest for the time being, where he was in delay with the salaries. And the team has a deadline to pay this award by the sole arbitrator. Now there's an issue. The team is still not paying Alex, although Alex has an award. So what can he do now? He has 2 options to enforce his decision. The first option would be the normal way of going to the state court, pursuant to the New York Convention. This is relatively expensive and time-consuming, and also in some of the countries, employment-related disputes are not arbitrable, so that could be refused as an enforcement. The other option, however, is very quick and free of charge, is that Alex comes to Riot Games Esports Compliance and requests that the award is enforced. Now, Riot Games, what they can do is that they can enforce sporting sanctions on the team until the award is paid. This means anything between fines and additional sporting sanctions on the team until he has his outstanding salaries paid. So this is kind of run through the proceedings. To kind of conclude, key takeaways are, again, we want to really establish contractual stability within our EMEA esports ecosystem. And we believe that if parties have this type of clause in their employment contract, they will be more likely than not to adhere to their obligations in that contract. We also believe that this will impose trust into our esports ecosystem. Let's say Alex, as a tier 2 player, will have trust in the Riot Games Esports ecosystem and can fully focus on his career that he does best and does not have to be worried if he signs a contract with one of the esports teams, whether or not this team will pay him. Of course, this goes the other way around as well. So I only mentioned here one example, but it also goes the other way around, that a team sometimes has issues with one of their players not showing up to practice or just leaving the team from one day to another. And of course, they can also use this, or in transfer agreements when the other team doesn't pay the transfer amount. And last but not least, we believe that implementing this will also be a positive side effect on the sustainability of the esports ecosystem as a whole. As I mentioned, it was launched on 7th of November, and you can find all the information on our website, competitiveops.riotgames.com, dispute resolution EMEA. You have the procedural rules, the FAQs, the user guide, anything is on there. And now I know we're already at 1 o'clock, so I don't want to take much more time if you have any questions.
Perfect. Thank you so much for the great presentation, and thank you even more for helping Alex to resolve his case. Really nice way of showcasing the DR